moja iliyoko hapa, kuna zaidi ya kesi 3. Kesi moja iko kwa political parties tribunal. Mahakama ya High Court haikujulishwa, ilihadaiwa. Tumeeleza mahakama kuna kesi nyingine katika hii mahakama. Hii mahakama haikujulishwa. Kwa hivyo tumezileta zote pale na tumeomba mambo mawili: zile oda zilizopeanwa na mahakama ziweze kubatilishwa hivi kwamba wale ambao walitimuliwa wabaki kuwa wametimuliwa njia mbili. Walitimuliwa katika nafasi za uongozi wa vyama vyao kuja bungeni, na pia walitimuliwa kutoka bunge na spika kwa sababu ya utovu wa nidhamu. Hayo ndio mambo tumeyaleta leo, tumeweza kufile, na tunahakika kwamba kesho mwendo wa saa 3, wakati ambapo jaji atapata makaratasi yetu, tutaweza kubatilisha ule uamuzi. Wale ambao ni wabunge halali wa bunge la Machakos County waweze kuendelea na kazi yao, wale wengine wafanye appeal pale. In summary, what I've said, used the Hansard for that day. We have produced the video clips showing the type of hooliganism, the type of conduct unfit for honorable member of parliament. We have produced the videos showing conduct similar to conduct of members of a group of hooligans, not a group of honorable members of parliament. Out of that, the speaker had to close the assembly indefinitely. This resulted into the National Senate summoning the speaker to go and explain the reasons. In paragraph 3 of the report of Senate is very categorical in paragraph 3 that this assembly must be opened to allow the statutory requirements, the statutory timelines to be met, and especially the budget making process, which comes to an end by 30th of June 2025. The Speaker of the County Assembly of Machakos, to the effect that orders have been obtained without material non-disclosure, without providing all the information to the learned judge. We have no grudge with the learned judge. The Speaker has full confidence with the learned judge of Machakos High Court, save that the judge was not given sufficient and full material to make a reasoned decision. The facts that we have brought to this court is that the first incident, the same MCAs contravened the provisions of the county assembly's requirements, standards. They involved themselves in a grave misbehavior where they barricaded the speaker and the staffs, and for more than 8 hours, an action that endangered the lives of citizens who are working in the county assembly. It endangered the honorable members of the county assembly. It endangered the members of the fourth estate who cover proceedings in the county assembly. It endangered the properties of the county assembly.
Yes. Today, we as the legal team of the Speaker of the County Assembly of Machakos have come to Machakos County because our client has been sued on more than one case on the basis of abuse of power, abuse of office, and other alleged grounds by rogue MCAs. Our instructions from the Speaker of the County of Machakos Assembly was to the effect that, number one, we respond to those allegations, and we responded to them very articulately, crushing each and every ground that has been raised with provisions of the law, and that at all times, at all relevant times, the Speaker was always acting within the confines of the law, and there is nothing that she has done that is outside what has been provided for the law. The court has also given orders whereby her mandate has been interfered with. Her mandate in discharging her constitutional functions as the Speaker has been interfered with. And in that regard, we have moved to court under a certificate of urgency with an application to have the same orders set aside and vacated as a result of material non-disclosure of facts and issues that the petitioners, who are the rogue MCAs, failed to disclose to the Honorable Court, and only relied on grounds that do not exist so that they can have the mercy of the court. And these orders were given without giving the Speaker the right to be heard. She was never afforded the right to be heard, contrary to provisions of fair hearing under the Constitution of Kenya, Article 50. And therefore, we are putting very serious questions before the court, that why such orders, which have been termed as temporary orders, have a final nature. That these orders that have been set aside, which are contradicting the mandate of the Speaker, are likely to cause grave injustices, and they are against the public interest of the people of Machakos County. So we are hoping that in the fullness of time that we will get justice, and that the court will be able to appreciate all the facts before it, before making any other pronouncement. Additionally, we have also raised a preliminary objection on the grounds that the MCAs who went before court went to court because they are alleging that there was a motion filed to remove the Speaker, and yet they were recipients of disciplinary action because of acting contrary to what has been provided for in the standing orders. And one of the provisions in the standing orders cite that internal mechanisms have to be explored, and because that has not yet been explored and exhausted, we have filed a preliminary objection on the two files, and we are waiting to see what the court will direct. I give the floor to you.
Your name, please.
My name is MS Martina Swiga, an advocate of the High Court of Kenya.
Martina
Swiga.